Good afternoon. This is Stephen Lewis. Let's jump right into the story today. Okay. This week's discussion is the weight of the law, looking at the civil right passage of the Civil Rights Act of 1964, and then some of the cases that literally just a mere couple of hours after Johnson signed the law into effect, filed a lawsuit against the federal government. So let's jump in. At 6:45 p.m. on July 2nd, 1964, President Lyndon Johnson signed the Civil Rights Act into law. By 8:55 p.m., Morton Ralston Jr. had filed suit. Ralston, president of the Heart of Atlanta Motel Corporation, did not wait to see whether the law would be enforced against him. Standing at the corner of Cortlandt and Harris Streets, adjacent to two interstate highways, his 216-room motel had refused to accommodate black guests. Since it opened 7 years earlier, he intended to keep it that way. In a 7-page complaint, Ralston argued that Title II of the CRA of 64 violated the Fifth Amendment by taking his private property for public use without just compensation, and that Congress had exceeded its authority to regulate commerce since his business, he insisted, was local in nature. He also sought $11 million in damages. The Justice Department called it the first major test of the Civil Rights Act of 1964. However, Ralston was not alone. In Jackson, Mississippi, the owners of the Robert E. Lee Hotel, the city's third largest, chose closure over compliance. They lowered the Confederate flag, shut the restaurant and nightclub, and assigned a clerk to turn away guests. In Birmingham, Ollie McClung refused to serve black customers at his barbecue restaurant. Both Ralston and McClung would carry their challenges all the way to the Supreme Court. But Congress was careful. Rather than grounding the Act's public accommodations provisions in the 14th Amendment, which the court had used to strike down the Civil Rights Act of 1875, lawmakers relied instead on the Commerce Clause, arguing that discrimination burdened interstate commerce. The court had read that clause expansively since at least 1824, and especially since the Judicial Revolution of 1937. That December, in Heart of Atlanta Motel, the United States, the court rejected Ralston's argument outright, ruling unanimously that Congress's commerce power reached any business whose discrimination, however local in appearance, burdened interstate travel. The companion case, Katzenbach v. McClung, extended the same logic to Ollie's Barbecue, holding that even a neighborhood restaurant fell within reach if the food it served had once crossed state lines. Together, the rulings closed off the most serious constitutional challenge the new law would face. Resistance in most places proved short lived. In the months that followed, the majority of businesses desegregated quickly and willingly, while a handful of holdouts, like the owners of the Robert E. Lee Hotel, preferred extinction to opening their doors to black guests. Yet the law's meaning did not end with its enforcement. Historians have continued to argue over exactly whom the Civil Rights Act was written to protect. Some scholars insist the statute, however broadly worded, was conceived chiefly with black Americans in mind, and that its later application to other groups arrived almost as an afterthought, settled by bureaucrats with little public debate. Others countered that the text's own language, banning discrimination on the basis of race, color, religion, sex, and national origin, reflected a wider reckoning with American prejudice from the start. One shaped as much by Lyndon Johnson's memories of teaching poor Mexican American children in Cotulla, Texas, as by the marches and sit-ins of the Black freedom struggle. That argument has never been fully settled. The law Ralston tried to overturn within hours of its signing had been built on a foundation broad enough to outlast the intentions of any single sponsor or signer. It had held, and with it endured, a principle larger than the men who first tested it, that no establishment open to the public could choose whom to serve because of who they were. Thank you.